Hi, I think I'm live. Double check. Let me come on over here. Oh, get out of there. The computer's running slow today. I finally got it to work a little faster, run a little faster, and shit, and then same way. Finally got it running a lot better, but then SnapCam stopped working. So then today I tried to apply like a different patch, and I came into issues, and so I found like this alternative. But now I'm looking at my screen and I'm moving all kinds of slow, so I'm not sure if it's a very good alternative. I don't know. Can you guys hear me and see me? Okay. Hi, Mimi. How are you? And I'm indulging. I'm having a bit of a cocktail today. It's like 2 a.m. here. I'm allowed. So yeah. I really need apple puckers for that. I don't like the apple schnapps. Whatever. But anyway. How was everyone? Hi. So yeah, there was a new court filing today. I don't know if y'all caught it or not, but that's interesting. I'm gonna go be reading that a little bit here shortly. I'm not gonna read it in its entirety, I don't think, because it's like there were several filings, and mostly like the two main filings there, and one of them's like 117 pages long, I think it said. The other one's a bit shorter, like 20 pages or something like that. I don't remember, but and it's already 2 a.m. But I want to come out for a little bit and stream it. And I haven't read much of these motions yet, so I do want to read them. And I figured, why not read them out loud? And I feel like my lipstick is bunching up here in the middle. All right, so let me see. Yeah, you guys can hear me okay, I think. Actually, I do sound kind of shitty. Let me double check my mic. Oh, you know what? I don't have it right in front of my face. That might be why. Do I have the right one? And yes, I do. Where'd it go? There it is. Okay. I'm mute it here for a second in case I hit shit or something. Okay, sound is back now. Don't fall on me. Come on, just stay right there. Perfect. Why is it gotta move on me? There we go. All right, now I got it. All right, so now I should sound a little bit better, because when this microphone, it's kind of touchy. Like, it has to be right up in front of my face. Otherwise, it just sounds like I'm a million miles away and underwater. I don't like it. So. Hi, Miranda. Good morning to you. Mm-hmm. All right, so like I said, there was a new filing today in the 7M lawsuit. This one came from Katie Joy's side, and basically she's well, I'll just pull it up and just, we don't have to do basically here. So these are the filings that were filed. Well, that popped up today. I'm not sure when exactly they were filed, probably like 2 days ago. But these are the ones that popped up today. So we have here for some 920, or actually they were filed on the 26th. They popped up today. There we go. Just answered my own question by looking at the page. We have notice of motion and motion index, memorandum, affidavit of attorney, and proposed order or document. So I'm going to just go over the small ones first so y'all can see what those are and know what they are, and then we'll get into shit. So let me get over there. So this here is the notice of motion and motion to deny temporary injunctions and to strike affidavits and pleadings and for appropriate sanctions for spoliation of evidence. Now, it sounds like this is just giving a brief little, like, I don't know, outline or list of what it is they're filing today. That's what this sounds like it is. So just, like a TLDR thing almost. Denial plaintiff's motion for temporary injunction, order striking the affidavit, order striking the memorandum of law, and sanctions against plaintiff. That's what this is just listing for you, for the court. And then we have the proposed order or document. It's the other smaller one. And this is just basically whatever side is pushing for a specific ruling or whatever. They'll like pre-type, they'll just type up the order just to make it easier on the judge. Just say, here, by the way, here's my argument. And, if by chance you rule in my favor, here where you go, all you gotta do is sign it. So that's common practice from what I understand. And then there's the memorandum and then the affidavit of attorney. So I'm going to pull both of these up, but I'm not going to get into both of them just yet. I think I'm going to go with the affidavit of attorney because that one has evidence in it, it looks like. So, but we're going to go I want to just read the title here for this one. So this is the defendant's memorandum of law opposing motion for temporary injunction and supporting motion to strike affidavits and for sanctions, yada, yada. So, and then just introduction, and it goes over like some of it, I guess. I don't know. I haven't read much of it yet. And then here's the big one, and this is the one we're going to stay on for a little bit. It's going to take a second to download too. All right, there we go. All right. I'm going to need my glasses for this. Okay. Let me see something. How badly do I look with them on, though? What happened? Your browser lost connection to your screen share audio. Oh, okay, that's fine. All right. Well, I'm not playing audio, so it's okay. All right. This is the 8th declaration of Jennifer Moore, who is Katie's attorney. Let me check chat before I go on. Hi, without a lawyer. Get me through my last hour of work, please. I'll do what I can. Hey, Tax Max Fax Thunderclap. Good to see you. All right, so here we go. Now, I'm not going to read all of the cases that they cite to make their legal argument or whatever, because though that is interesting, that's not why I'm here really for the most part. And I don't think that that's why a lot of other people are here. If they are here, it's mostly just to hear about the meat of it all regarding the events that transpired and the actions of the defendant mostly. I think that that's why most people are here to listen to this. So I'm going to stick to that for the most part. So it says, I am an attorney licensed to practice law in the state of Minnesota and counsel of record for defendants Catherine Mansky Paulson and Without a Crystal Ball LLC. I submit this affidavit to authenticate. I'm already off to a great start. Awesome. The exhibit cited in defendant's memorandum of law opposing plaintiff's motion for temporary injunction, motion to strike, and motion for sanctions for spoliation of evidence. Attached here to are true and correct copies of the following documents. Exhibit 1, unpublished Minnesota authorities cited. And then, see, this is what I mean by like some of the precedent case laws and stuff. But then they also added Exhibit 2, the LA Times article, the home of TikTok cult pastor and sex trafficking fraud investigation. Then the LA Fox 11 article, who was Robert Shinn? Then the People article, Miranda Derrick and James B. Derrick wiped their social media accounts. Exhibit 5, Daily Mail article, mystery as Dancing for the Devil star abandons millions of followers. Well, it's not really a mystery on why she did it. I mean, or why they did it, rather. They said as such, they gave reason as to why they did it. And it's because of the bullshit and the harassment that they were getting as a result of Katie Joy's reporting, allegedly, whatever. Internewscast Journal article, Dancing for the Devil star cuts ties with followers. Exhibit 7, cross defendants ex parte supplemental application for an order to seal documents. Exhibit 8, declaration in support of motion to stay. Exhibit 9, supplemental brief in support of plaintiff's request to stay civil action pending criminal action. Exhibit 10, supplemental declaration in support of supplemental brief in support. Okay, you get the gist of it. Says these documents are offered to provide competent evidence supporting defendant's opposition to plaintiff's motion and to demonstrate plaintiff's inconsistent positions, spoliation of evidence, and failure to satisfy the standards for injunctive relief. Further, your declarant saith not. Okay. I declare under, okay, so there she signs it. So we have Exhibit 1. This is referencing a court case prior. There's non-precedential opinion. Well, I want to read this a little bit. In this dispute over harassment restraining order, appellant argues that the district court abused its discretion by denying her request to recuse itself for bias, abused its discretion by granting respondent's HRO against appellant, and erred by determining that appellant's harassing statements about respondent were not protected under the First Amendment. We affirm. Respondent Rebecca Lynn has been employed as a legal secretary with the Itasca, County Attorney's Office for 16 years. Prior to this, she was employed with the John Dimich Law Office for 10 years as a legal secretary. Appellant Rose Marie and John have been friends for 40 years. While employed at the John Law Office, Rebecca Lynn I can't pronounce some last names. That's why I just stick with the first names. Would occasionally see Schumacher. Oh yeah, Schumacher. Okay, would occasionally see Schumacher there. In the beginning of 2022, 2 employees not involved in this appeal from the county's attorney's office were discharged from their positions with that office, but remained employees of the county. During this time, John was running for county attorney against incumbent Maddie Adam, Rebecca's supervisor. On July 10th and 12th, Schumacher posted comments on social media titled, Itasca involved, informed, inspired about fidelity. On June 10th, Schumacher posted, Maddie is desperate and her intimidation tactics are ramping up. It's coming out, Maddie, whether you wanted to or not. Becky isn't the only leaker in your tight circle, emphasis added. On July 12th, Schumacher posted, outside agencies are watching because no one currently serving Itasca County has the balls or just love the gravy train they are on and throwing each other under the bus. Right, Becky? Having an alleged offender you ask special favors for in your parade marches is for sure an FU to Itasca County and her victims, especially our victims she continues to victimize. Okay. Shoemaker also posted a photograph of Fidelity that day and stated, the squeaky leaker. This is not her first time leaking private info, insinuating that Fidelity had leaked information while employed at the John Law Office. She further stated in that comment, quote, you are pathetic. But I have known that for years. Karma, baby. Following the comments, Fidelity petitioned for an HRO against Shoemaker. The district court held an evidentiary hearing on August 4th and issued an order granting Fidelity an HRO against Shoemaker. Less than a month later, Shoemaker filed a motion for post-trial amended findings requesting that the district court deny the HRO. In her motion, Shoemaker argued that Fidelity failed to show the requisite harassment for an HRO and that the district court a district court judge failed to disclose a conflict of interest to the parties prior to the hearing. The hearing court held another hearing and denied Shoemaker's motion, stating that, quote, there was and is no conflict of interest by this court. And after review of the arguments of the motion hearing, as well as the record and transcript of the evidentiary hearing, there is no reason to change the decision of the court. This appeal follows. Decision. 1. The district court judge did not abuse its discretion by denying Shoemaker's request to recuse themselves for bias. Shoemaker argues that the district court judge should have recused themselves because they knew two people that were mentioned in the social media comments and therefore expressed bias. We are not persuaded. See, okay. If you're a judge for like your city, your town, whatever ordinance, especially if it's someplace like suburban or rural, you're going to constantly have people in front of you that you know. I mean, it's unavoidable. You're a judge. You live there. You're going to know people who appear before you. I mean, I think that one of the things that they train and they learn on how to do other than just, argue law is to do so with the least amount of bias as possible, to remain just fair as much as they can, so I mean, I think it's just kind of, I don't know, I think you need more than just the fact that they know people. I think you need more than that to argue for recusal, in my opinion. Unless they're sleeping with one of them, that's different, I guess, but whatever. We will not reverse the district court's decision to deny a removal motion absent an abuse of discretion. Yeah, that makes sense. All right. There was no conflict of interest. The record supports this determination and reflects that the district court did not show bias. Shoemaker points to the district court's comment at the evidentiary hearing. I mean, come on. I love how Ms. Shoemaker says she's respectful, and I know DH, calling her dead weight, and then in parentheses, two heavyweights, along with AC, real respectful, Ms. Shoemaker. Whatever. I don't really care about this. So wait a minute. Is her attorneys using this as an argument to support their opinion or something? I don't get it, but I don't really, whatever. Maybe I'll get it later or something, but I'm going to skip over this part. Oh wait, no, this is a new one. No, it's not. Okay. We review whether the district court's granting of the HRO against Shoemaker violates her free speech rights de novo. Well, I mean, in what way was her speech restricted, though? I don't get it. She just couldn't, bother the person, right? I mean, anyway. All right. I'm sorry. I don't have it in me to sit here after 2 a.m. and read about the First Amendment precedent argument in the state of Minnesota. So we're going to go ahead and skip down to this. So here we have Exhibit 2. This is the LA Times article reporting about how the pastor in trafficking and fraud investigation, how his home of, this TikTok cult's home was raided by federal agents. And here we have the article stating, a home linked to a pastor featured in the Netflix docuseries Dancing for the Devil, the 7M TikTok cult, was raided Friday by federal agents in relation to an investigation into trafficking, money laundering, and other accusations, according to authorities. Property records show the home in the 7700 block of McRoarty Street is linked to multiple owners, including Robert Shinn, pastor of the Shekinah Church and the subject of the 2024 docuseries. He operates a talent agency that purportedly helps social media stars and TikTok dancers find jobs in LA. A previous version of the story incorrectly identified the pastor of Shekinah Church. Oh, his first name is Robert. Okay. Those featured in the docuseries call Shinn an abusive cult leader. They say he kept them away from their families by telling them that in order to be saved, they had to, quote, die to their loved ones who did not follow his teachings. He reportedly told them that if they were godly enough, they would also save their families from damnation. On Friday, agents from the U.S. Postal Service, Internal Revenue Service, and U.S. Department of Labor served a warrant at the home about 6 a.m. So, according to El Monte Police Department, which provided assistance along with the FBI. So the FBI was only there in an assistance capacity. They weren't there in a like leading investigatory fashion. Huh. I didn't know that. That's interesting. The search was related to allegations of trafficking, money laundering, tax evasion, and COVID-19 pandemic era related fraud. So he was selling like fake vaccine cards or something, I'm guessing. The search was done in relation to the allegations of trafficking and money laundering and IRS and wonder where that shit came from. Postal Inspector Patricia said in a prepared statement that officials will provide more details as the investigation progresses. U.S. Postal Inspection Service is working closely with our local, state, and federal law enforcement partners on this ongoing investigation. This remains an active case, and we are continuing to gather and review information, Mendoza said. Law enforcement sources familiar with the investigation say the federal warrant is connected with the alleged cult featured in the Netflix docuseries, but details from the investigation remain under seal in federal court. News video from KTLA showed several handcuffed people outside the residence, but sources familiar with the investigation say there have not yet been any arrests. On Friday afternoon, the two home bustled with onlookers, curious neighbors, and news vehicles. The gated entrance to the home was visibly twisted and warped, having been rammed by federal agents early that morning, according to neighbors. I was getting ready for work when I heard the flashbangs go off, said one neighbor, Jake Hartman. Then, over a loudspeaker, "You need to come out, hands up." All the neighbors came out to find FBI, Sheriff's Department, and police taking up the whole area. An open gate is apparently unusual for the home. Several neighbors said that in the few years that the alleged cult lived on the property, it was constantly blocked off. The owner reportedly built higher walls and grew trees to further block views of the home. When they moved in, it was weird, said neighbor Marge. They were very secretive. Then they sent out a flyer of what they wanted to do. They said they wanted to do all these things for our community, like letting scout troops meet at the house, doing prayer meetings at night, letting people swim in the pool. It was so bizarre. Oh, okay, so this is where Katie finds the door cracked open for some good old-fashioned SA abuse claims or whatever. I don't know. That's what, oh my God, I think that might have been the alert that Michael got earlier. I couldn't find it. I was wondering what the hell it was. Well, not this specific one, but from the same app, I'm thinking. Interesting. The property is large, wrapping around a street corner and lined with a thick wall of trees. Wagner recalls the owner taking back initial offers for a community space and giving mixed messages on the purpose of the property, a move that confused several in the community. The owner instead said in local meetings that they would hold a men's prayer night there every Tuesday, Wagner said. For him to say that it was a church and only have one event a week for men, I thought, this isn't right. Nothing seemed right. Anthony Jackson, who lived next door for years, said he interacted with the residents of the property many times. Jackson described the neighborhood as quiet, with mostly older residents, and says he never saw any red flags. Shinn's wife is very nice. I've never seen anything out of the ordinary, heard anything out of the ordinary, Jackson said. So when I saw the changes or charges on the news, I couldn't even believe it. I mean, I still don't believe it. Okay. In response to a request for an interview, the man replied, I don't want to get caught up in all this. I just live here. They'll see soon that it was all just a misunderstanding. Probably, I think so. It was not immediately clear whether Shinn had any legal representation. The docuseries follows former Shekinah church members who worked with the 7M Films talent agency, which was founded by Shinn in 2021. The series reveals that the dancers who were represented by the talent agency started as social media collaborators who frequently posted dance videos together on TikTok. But members of that group found themselves attending Bible study with Shinn. Those dancers invited friends to join what eventually became the core group of the alleged cult. Shinn reportedly called himself, quote, the man of God, and said his teachings would grant his followers salvation. Yeah, that's fucked up. Okay, is that it? Oh, okay. Then we have the Fox 11 article, Who was Robert Shinn? TikTok called Pastor Detained, following raid in LA. I think it's all going to pretty much say the same shit. In the documentary, people, including some who were minors, alleged that they were forced to perform for low wages and were cut off from their families. They also alleged that they were forced to overturn parts of their wages to the church. Many said Shinn created a cult-like environment. Now, I mean, I was raised Catholic, and the Catholic Church sends out with their newsletter or whatever every week, I think it is, my donation envelopes or whatever. They're expecting that everyone in the parish is going to donate or whatever. So I get that. I'm whatever. I think that that's probably worse than what was probably happening here, because yes, Robert Shinn was the pastor, and maybe he did, put like a mandatory, like a percentage of their pay or whatever to go to him. But in exchange, he secured them jobs, contracts, also helped provide all the tools needed and necessary to make online content, to upload to various social media platforms, in which they were all monetized. So therefore they made money. They all made money. So, I mean, and I guess it was his property that they were even living in. So, I mean, it's kind of a monopoly-like situation that I don't agree with, but I mean, it's not like the money he was asking for is, I'm going to venture a guess here and say it's about the same amount of money that any adult living on their own is going to have to expect to pretty much put out there to do so. My opinion, whatever. Let me check chat here real quick. Hi, JLB. Yeah. It's funny, if Katie talks about the documentary, it's a promo, but if someone tries to discredit it, Katie thinks it's slander. Oh, that reminds me too. I want to pull something else up. I probably should have just got it off of Twitter. Yeah, I'm going to go to Twitter and get it. Okay. There's been some screenshots too that have been posted from her. I think it's from her Instagram. I think that's like the only platform she's even on anymore. My computer is slow again. I hate this. All right, so over here on pulled up Ball's page. And here she posted, I'm sharing these screenshots as they will be needed to point out Katie Joy lying under oath, twisting the truth, and completely rewriting history. This is, y'all, this is so bad for her. Her filing is an auto-pen chat GPT rambling rage-fueled mess. Come on. Okay, just the same thing I already read for the most part. Same there. Oh, no, that's the old filings. That's what that was. The discovery Robert Shinn provided me in court shows forged taxes, marriage licenses, and business contracts. It proves Miranda Derrick has no control over her life, marriage, and finances. I hope the feds rate his lawsuits. What? How do you rate a lawsuit? Oh my, what is she talking about? It's crazy. It's so crazy. Based upon other legal signatures of Miranda Derrick, we are 90% confident her signature is forged on this marriage license. Oh my God, whatever. Anyway. It's getting hot in here. Miranda James Derrick marriage license lists Shirley Kim, young Kim as the witnesses. Okay. This is from June. Plaintiffs, she highlighted, any discovery disputes shall be brought via separate motion. Okay. All right, so there's that post. I'm just looking for screenshots right now. Oh. Sorry. Why is it that I was not been tired all night, but then I sit down and do a stream and have 2 sips of booze and I'm ready to go to sleep? It's crazy. That's it. She didn't. Okay. The last 2 pages are the most important, Ball says. So go to the last 2 pages. So it's gonna be that one and this one, right? Okay, so yeah, we already looked at that one, I think. Okay, I'm going to open this up in another tab here, make it easier. All right, here we go. Witnesses or forged documents. These are not quotations, they are paraphrases. Plaintiffs cite sprawling 90-minute video recordings and entire social media streams without identifying the specific passages they claim are objectionable. They expect this court to sift through hours of content and guess at what plaintiffs find offensive. That is not the law. In defamation, liability turns on the actual words used, read as a whole and in context. Minor variations that don't change the gist aren't actionable. Without them, the court cannot evaluate whether the statements are factual assertions, protected opinion, rhetorical hyperbole, or substantially true. The problem runs deeper than lack of specificity. Plaintiffs' affidavits consist of little more than the conclusory claim that, quote, no charges have been filed. That truism neither establishes falsity nor disproves the existence of an investigation already documented in public reporting and confirmed in plaintiffs' own California filings. At the same time, plaintiffs omit contrary sworn admissions from those California proceedings, admissions that directly undermine the narrative here. Plaintiffs also distort the nature of the commentary they seek to enjoin. They argue defendants accuse them of, quote, forging documents and, quote, coaching witnesses. In reality, the forged documents references were criticisms of plaintiffs' litigation conduct, specifically their repeated practice, both in California and here, of submitting documents under plaintiff signature that are neither sworn nor wet ink executed. This is a procedural defect, not an allegation of criminal forgery. Likewise, Paulson's commentary on witness coaching was based on deposition testimony already in the public record and on her own firsthand observations. Nothing about those comments concerned material under a protective order or otherwise confidential. Plaintiffs attempt to reframe such litigation criticisms as, why won't it let me go back? Come on. It's annoying. This is a procedural defect, not an allegation of criminal forgery. Oh, wait a minute. Right, just running here, submitting documents. Okay. Not an allegation of criminal forgery. Likewise, Paulson's commentary on witness coaching was based on deposition testimony already in the public record and on her own firsthand observations. Nothing about those comments concern material under a protective order or otherwise confidential. That's a very good point. Plaintiffs attempt to reframe such litigation criticisms as why does it keep getting stuck? Oh, I'm an idiot. It's because I'm on the extra tab. I'm such an idiot. Okay. All right, we already read that one. Go back to this tab here for you guys. Wow. All right. Okay, so I'm going to do some reading over here. Right? No, it does that. Okay, so this page here I want to read. Measured against this framework. Oh. Courts are instructed to apply these factors with particular caution where speech is involved because the First Amendment erects a near absolute bar against prior restraints. The Supreme Court has described such restraints as, quote, the most serious and the least tolerable infringement on First Amendment rights. Measured against this framework, plaintiff's motion does not merely falter, it collapses. They make virtually no attempt to address the Dahlberg factors. They offer no legal authority authorizing the remedy they seek, and they provide no factual record that could justify gagging a journalist on matters of public concern. That omission is telling. What? Is she making an argument because it's based on regarding shit they didn't say? Did I read that right? As they provide no factual record that could justify gagging a journalist on matters of public concern, that omission is telling. Plaintiffs know the factors cut against them. Their motion is not about satisfying the law, but about sidestepping it. And a couple of articles on merit, it looks like. Okay. All right, I'm just going to X that out then for now. What the fuck? All right. Katie lies under oath claiming she did not dox Miranda and James Derrick. Oh, that is a lie. That is. Plaintiffs, this is, who's it? Balls is speaking. I'm not sure who shared this with Balls, but whoever shared this with Balls is probably likely the first person speaker here. Is that first person? Yeah. Plaintiff's doxing argument fails. Plaintiffs may argue that loosening designations would enable, quote, doxing. That argument is unfounded. Defendant Paulson has never disclosed a private addresses or PPI obtained through discovery. Her reporting was based on publicly available sources, corporate filings, court records, and social media content plaintiffs themselves chose to publish. The protective order already protects truly private data. What plaintiffs seek here is not protection from doxing, but insulation from scrutiny. They are attempting to prevent the defendant from reviewing, contextualizing the very evidence she is accused of misusing. That misuse of designations is inconsistent with Rule 2603 and the protective order's plain language. Okay. Oh, now she's claiming under oath that she did not dox Miranda or James Derrick. Wow. Okay. I'm going to check chat here real quick. Hi, guys. All right. I'm going to take a 2-minute break. I'm going to smack my face around or something, wake up a little bit, and I'm going to do some more reading. I will be right back. I'm going to play the intermission music for you, and I'll be back by the time that shit's over, or right around the time that shit's over, I think. Actually, I don't know if it's going to let me play that now because they changed their settings or whatever. Here. Yep, that's not going to let me play it. God damn it. All right, so I guess we're stuck listening to ducks or some shit. We'll do night driving. Be right back. Okay. Turn off. Here we go. Okay. Oh, shoot. Wait a minute. Okay, there we go. Okay, I feel a little bit better now. A little bit more awake. Got the fan on me. So, oh my God, cat, you scared the shit out of me. All right, check out chat one more time. Okay. Let's carry on then. Oh, it's right. I was over in this. I'm going to go jump. Wait a minute. Okay, so we're going to read this one here real quick. All right, Kitty. So, okay. Oh, okay. Kitty wants to give me a hug. Oh, hi. Okay. I'm going to get done, though, okay? I'll curl up and I'm done. Okay, this here, Katie does not attack other creators. How dare you? And literally the rest of the internet. I actually have been friends with Ken since we were both subpoenaed. She has been nothing but kind and honest. She is transparent and doesn't play games. I don't attack other creators. Okay. That's funny. In this case, Ken's, and I have spoken about this issue with the subpoena and even debated. You are too cute. You are too fucking cute. You know that? And even debated how this got leaked. So don't create beef where none exists. All right, I think that's about it. I mean, she did post a lot of other crazy shit here, but I already read that, so we're gonna move on. All right, so back to here. This is from the Fox. No, I already read that one. Didn't I? Mm-hmm. No, I didn't. That's right. Those featured in the docuseries called Shinn an abusive cult leader. They say he kept them away from their families by oh, I already read all that. Yeah, I did. Okay. I did move on to the Fox one, I think. All right. I was getting ready for work when I heard the flashbangs go off, said one neighbor, Jake Hartman. Then over a loudspeaker, "You need to come out, hands up." All the neighbors came out to find FBI, Sheriff's Department, and police taking up the whole area. I already read that part too. Where did I leave off then? Jesus. Declaration, Exhibit 3. Who is Robert Shinn? TikTok cult pastor detained following raid in LA. A raid was conducted last week at a home tied to Robert Shinn, who was the subject of the Netflix docuseries Dancing for the Devil, the 7M TikTok cult. Law enforcement officials told Fox 11 that Shinn was detained but not arrested. Multiple warrants were served during the raid for crimes such as money laundering, fraud, tax evasion, as trafficking, and COVID-19 pandemic fraud. What we know, FBI agents and the Almonte tactical team conducted a raid at a home located in the 7700 block of yada yada. Arrest warrants were served for multiple crimes, including money laundering, mail fraud, tax evasion, as trafficking, and COVID-19 pandemic fraud. What does that mean, arrest warrants were served? Because from what what we've all been hearing is that there have been no arrests as of yet. So isn't it arrest warrants the paperwork required for executing an arrest? So if arrest warrants were served for multiple crimes, then why was no one arrested? I don't understand that. The 5 warrants were served at 5 different properties. But that doesn't say arrest warrants, though. Right there, that just says 5 warrants. That could be search warrants. Especially if they were served at 5 different properties and there were 5 warrants served. That would make sense, I think, but okay. Whatever. There's no word on any official arrest. Dig deeper. According to legal expert Mary David, Shinn could face multiple charges, including as trafficking, tax evasion, money laundering, and mail fraud. The highest penalty would go to the S trafficking that carries a sentence of 15 years to life. Participants in the docuseries accuse church leader Robert Shinn of labor exploitation and misconduct. In the documentary, people, including some who were minors, alleged that they were forced to perform for low wages and were cut off from their families. They also alleged that they were forced to overturn parts of their wages to the church. Coercion is especially sinister when it involves a religious leader, which is an element to prove in a trafficking case. If you're talking about adults, and here where you have a religious leader who is almost seen as a connection and gateway to God for victims, that presents an incredibly powerful and persuasive figure for them to then feel like they are potentially risking their salvation or the salvation of others if they don't do what they say. After TikTok dancers join a management company and its associated church, unsettling details about the founder and their dark realities come to light, the Netflix description reads. What's next? Federal authorities are planning to present the case to a grand jury. Then we have the 8th declaration or exhibit or whatever. Miranda Derrick and James B. Derrick wiped their social media accounts weeks after feds raid Pastor Robert Shinn's home. Miranda Derrick and James B. Derrick, a married couple at the center of Netflix's 2024 docuseries, whatever, have wiped their Instagram and TikTok accounts. The update comes weeks after federal agents raided a property associated with 7M Films head Robert Shinn. Excuse me. Miranda's family has previously claimed that she is in a cult, allegations that Miranda and 7M Films have vehemently denied. So, I want to scroll through this real quick. I want to see. All the news articles say pretty much the same thing, but wow. So, you know who? I remember hearing about their social media accounts being deleted or whatever, or no longer being there, and I heard about it like hours after it happened, apparently, because Katie did an interview on a YouTube channel stating that they took all their shit down probably to like help conceal evidence or whatever, because of the raids and shit. And then after that, seemingly all of these other media outlets jumped on this explanation and presented it as well. And if that's not true, So are these all news articles? Oh, the video, Jesus. I see something. Oh, the comments. People doing dorky dances and the losers who watch them. Oh, that's funny. It is entertaining to watch. I don't give a shit. Okay, here we go. That's what I wanted to see if there was anything else up. All right, so Superior Court of the State of California, County of Los Angeles, whatever. RCP Financial Incorporated, California Stock Corporation, 7M Films, Shekinah Church, Robert Shinn, Hannah Grace as plaintiffs suing Priscilla Lee, Melanie Lee Goldman, Haley Marie Carroll, Haley Elizabeth Phipps, Kaylee Irene Schaefer. So this is the lawsuit that was filed in the state of California. I don't think that this was a federal lawsuit. I think it was just in the state of California. And it was filed against a couple of former members who had been like pretty much feeding Katie like all this bullshit information. And I say bullshit information because they already tried to sue on it once and the courts ruled against them. So that kind of, I don't know, it kind of makes it at least seemingly bullshit. And the other names up there are the other Instagram accounts that Katie Joy has had spewing her fucking rhetoric. Exhibits A through J to the Declaration of Daniel in support of cross defendants concurrently filed supplemental brief. Okay. Declarations of, why are people redacted? Who doesn't want their declaration out there? The sealed record shall remain sealed unless and until further court or further order of the court. This motion is made pursuant to California rules of court. Sought to be sealed. Why are they sealing it though? Like I know that Robert Shinn filed to have like a stay or whatever put on this case until this newly arising now like federal potential criminal case, is concluded. I get that. But is that all the protective orders for? Is that why they're sealing it? Is for that reason? Yeah. Okay. Yep. That's it. Exigent circumstances warrant granting this application because if the requested records are not sealed, cross defendants will face irreparable harm in the form of public exposure of grand jury subpoenas and contents of a confidential criminal investigation, as well as being deprived of providing a complete record of evidence to support its concurrently filed motion to stay the civil action. Yep. Okay. So that's what that was about. So that lawsuit is pretty much like just paused, put on hold. And here they explain. The records sought to be under seal in this action are strictly confidential grand jury subpoenas issued by the United States District Court, correspondences from the United States Attorney's Office, filings that recite the contents of the aforementioned records. Notably, these records are strictly secret and not publicly accessible as they are part of secret grand jury proceedings and or an active criminal investigation. Good cause exists to grant this application because there are overriding interests in preserving the secrecy of grand jury proceedings and confidential investigative information, preserving cross defendants' privacy, and maintaining judicial deference to the already confidential nature of these documents as decided by the federal court and federal rules of criminal procedure. Okay, interesting. All right, so I'm going to scroll through this for a second. And it's most okay. All right, so I'm not gonna focus on that lawsuit at the moment. Is that it though for exhibits really? Okay, here's what I want to get to. All right. To plaintiffs by and through their attorneys, pursuant to Minnesota rules of civil procedure 26, 33, and 34, defendants Catherine Paulson without a crystal ball LLC require that you answer the following interrogatories in writing and under oath. In answering these interrogatories, furnish information available to you, however obtained, including hearsay and information known by or in the possession of your agents, including your attorney. If any interrogatory cannot be answered in full after exercising due diligence to secure the information, answer to the extent possible, specifying your inability to answer the remainder, stating whatever information and knowledge you have concerning the unanswered portion, and detailing what you did in attempting to secure the unknown information. Okay, well, that wasn't what I thought it was going to be. So this is her still trying to push for some evidence or whatever. All right. So I think we're towards the end of that. I am going to read a little bit of the other one because I did touch that a little bit. I mean, this goes into more detail and stuff if you want to read it, but the other order, the one that's only 23 pages long, gives a little bit more of an explanation, I think. Plaintiff's motion for a temporary injunction is not merely defective. It is constitutionally impossible. What plaintiffs ask this court to impose is a classic prior restraint, a form of censorship the United States Supreme Court has condemned as the most serious and the least tolerable infringement on First Amendment rights. Minnesota courts have been clear. There is no authority for prior restraints outside the harassment restraining order context. Plaintiffs know this. In fact, this very court already denied their prior request for injunctive relief in 2022. Nothing has changed. If anything, plaintiffs' present motion is weaker. It offers virtually no facts that could satisfy even the barest threshold under the Dahlberg test, much less overcome the heavy constitutional presumption against censorship. This motion is not a genuine request for equitable relief. It is a procedural stunt. Plaintiffs filed it to accomplish three impermissible ends. One, to smuggle new evidence of supposed malice into the record in a transparent attempt to poison defendants pending reconsideration motion. Two, to distract from their own discovery failures and litigation misconduct. And three, to punish defendants by silencing a journalist and multiplying defense costs. Plaintiffs do not seek an injunction because they know no injunction can issue. They seek leverage. This court should see the tactic for what it is: abusive, unconstitutional gamesmanship, and deny the motion in its entirety. Factual background. The LA Times reported the federal agents raided the home. That raid was not speculation. It was publicly confirmed and widely covered by national and local media. Nor was it the only sign of federal scrutiny. What other signs were there? In contemporaneous California litigation, plaintiffs moved to stay civil proceedings, admitting they had received grand jury subpoenas and correspondence from the U.S. Attorney's Office, and acknowledging that the federal investigation concerns the same subject matter as civil allegations of trafficking, fraud, forced labor, and related criminal conduct. Cross-defendants ex parte supplemental application. Okay. Oh, this is where it's just going into like the stay or whatever I was just reading from the other one. Okay, yet in this court, plaintiffs now insist it is false to report that they are under investigation. Both positions cannot be true. Their willingness to acknowledge federal subpoenas in California while denying them in Minnesota reveals not confusion, but strategy. They seek to suppress accurate reporting when it suits their procedural aims. Plaintiff's motion for temporary injunction is remarkable for what it does not contain. Nowhere do plaintiffs identify the precise words they claim are false. Instead, they rely on sweeping characterizations that defendants, quote, accuse them of trafficking, fraud, forced labor, and other criminal conduct. The defendants, quote, misrepresented this court's rulings. She did, but Katie Troy did misrepresent them. I mean, okay. That defendants, quote, coached witnesses or forged documents. These are not quotations. They are paraphrases. Plaintiffs cite sprawling 90-minute video recordings, our entire social media streams, without identifying the specific passages they claim are objectionable. Okay, I read that part already. The problem runs deeper than lack of specificity. Plaintiffs' affidavits consist of little more than the conclusory claim that, quote, no charges have been filed. That truism neither establishes falsity nor disproves the existence of an investigation already documented in public reporting and confirmed in plaintiffs' own California filings. At the same time, plaintiffs omit contrary sworn admissions from those California proceedings, admissions that directly undermine their narrative here. Plaintiffs also distort the nature of the commentary they seek to enjoin. Okay, I think I read this prior already. They're accused of forging documents, coaching witnesses. In reality, the forged documents references were criticisms of plaintiffs' litigation conduct, specifically their repeated practice, both in California and here, of submitting documents under plaintiff's signature that are neither sworn nor wet inked executed. Oh my! Are you kidding me? Really? Oh, you're not going to get anywhere on that argument, I don't think. That is a procedural defect, not an allegation of criminal forgery. Likewise, Paulson's commentary on witness coaching was based on deposition testimony already in the public record and on her own firsthand observations. Nothing about those comments concerned, but her firsthand observations, she didn't observe actual coaching. She observed advocates, whatever, working on behalf of the plaintiffs, and she didn't like this, so therefore they must be coached. Like, okay. Nothing about those comments concern material under a protective order or otherwise confidential. Plaintiffs attempt to reframe such litigation criticism as conduct or as false criminal accusations exemplifies their strategy. They conflate legitimate commentary on their conduct with defamatory allegations of misconduct, hoping the court will not notice the difference. In short, plaintiff's evidentiary presentation falls into three categories. One, conclusory paraphrases that fail to identify the actual statements at issue. Two, generalized reputational complaints unmoored from any specific July through August 2025 posts. And three, omissions of contrary sworn admissions confirming the existence of a federal investigation. Neither of these categories supply a basis for injunctive relief. Together, they confirm that this motion is not grounded in fact. It is grounded in contradiction, omission, and strategy. Plaintiffs seek a prior restraint. The First Amendment flatly forbids. Plaintiffs are asking this court to do the one thing the Constitution most clearly forbids: silence a critic before trial. The Supreme Court has called prior restraints, quote, the most serious and least tolerable infringement on First Amendment rights. Minnesota's own history gave rise to that doctrine. The principle has remained unchanged for nearly a century. Government cannot gag a speaker before the words are spoken. Yet that is precisely what plaintiffs demand here. They do not disguise it. They ask for an order forbidding defendants from speaking at all about them on matters of undeniable public concern. No narrowing, no tailoring, no acknowledgement of constitutional limits, just a blanket order of silence. And plaintiffs know they are not entitled to this relief because this court has already confronted this identical request. In 2022, plaintiffs sought a temporary injunction to silence defendants' reporting. The court denied that motion, and rightly so. Minnesota courts have never permitted a prior restraint outside the narrow harassment restraining order context, and they certainly have never censored a journalist covering matters of public controversy. Plaintiffs are fully aware of that precedent. They lost this argument once. Their choice to recycle it now, stripped even of the minimal factual support they offered last time, confirms that this motion is not a genuine bid for equitable relief, but a tactical maneuver designed to burden their opponents and this court. Furthermore, the lack of factual support is striking. Plaintiffs have not even tried to satisfy the Dahlberg factors that govern injunctions in Minnesota. They do not show a likelihood of success on the merits. They do not show irreparable harm because reputational injury is compensable, if at all, through damages, not injunction. They do not weigh the balance of harms, which here tips decisively against silencing speech. They do not explain how the court could possibly enforce such an order without becoming a line-by-line censor of commentary. Plaintiffs simply leap past these requirements and demand that one remedy our law will never allow. That is not an oversight. It's a tactic. Plaintiffs know they cannot obtain an injunction. They ask anyway, not to win, but to punish defendants and to plant improper malice rhetoric in the record. The Constitution does not permit it, and this court should not indulge it. I would skip over that part. Likelihood of success on the merits. Okay, that talks about malice. Oh, okay. The law is clear. Public figure plaintiffs must prove actual malice, meaning publication with knowledge of falsity or reckless disregard for the truth. Plaintiffs ignore this controlling precedent. Their motion is riddled with references to defendants' malicious tone, their persistence in criticizing plaintiffs, and their refusal to stop reporting. This is common law malice, not Sullivan malice. Minnesota courts have repeatedly warned that mixing up the two is fatal. Fatal. Even if plaintiffs could articulate the correct standard, they cannot meet it. The record is full of online commentary, opinion, rhetorical shorthand, and hyperbole, the kind of speech Minnesota courts have consistently protected. Plaintiffs' failure to engage with the actual malice standard underscores why they cannot prevail on the merits and why their injunction must be denied. Threat of irreparable harm. Plaintiffs also fail to show irreparable harm. They allege reputational injury, but reputational injury is the paradigmatic harm addressed by damages, not by injunction. Advanced, oh, okay, am I reading that? Damn it. Shit. If plaintiffs prevail, a jury can award damages. That is the remedy the law provides. Okay. I think I'm reading here. I'm going to turn the camera off for a second. Okay. I got a pimple there and I just hit it right. Plaintiffs' own conduct belies any claim of urgency or irreparable harm. They have tolerated years of reporting without seeking retractions or corrections. Only now, with summary judgment reconsideration pending, do they suddenly point to a handful of July to August 2025 posts as the basis for emergency relief. Delay is fatal to claims of irreparable harm. Urgency that materializes only when convenient for motion practice is not urgency at all. It is proof that plaintiff's motion is tactical rather than remedial. Why can't I read tonight? Balance of harms. The balance of harms is not close. Plaintiffs complain of reputational discomfort and injury compensable through damages. Defendants face the most serious constitutional injury imaginable, a gag order forbidding them to speak on matters of public concern. That harm is irreparable and permanent. You know, it's funny just to see her make this argument. It really is. The most serious, I mean, this is the person who tried to shut up her haters for 10 years, if not a lifetime, because they basically, pointed out her lies. This is crazy to see this argument coming from her, of all people. Wait, what? Plaintiffs chose to file this high-profile defamation lawsuit. They placed their reputation squarely at issue. They cannot now demand immunity from the very debate they provoked. The First Amendment does not permit litigants to use defamation suits as both sword and shield. The balance of harm weighs entirely against censorship. Public policy considerations. Public policy decisively favors denial. The First Amendment protects not just the right of defendants to speak, but also the right of the public to hear. The subjects at issue here, allegations of trafficking, cult control, and financial exploitation, are matters of undeniable public concern. Plaintiff's motion seeks to suppress that debate. Yeah, but the whole point, they're not trying to shut her up for life. They don't want the damages to They don't want more damages to pile up on the damages being argued upon now. It, at least that's what I would think. Courts have repeatedly recognized the chilling effect of defamation claims on public discussion. The United States Supreme Court has been equally clear that restraints on speech must be narrowly tailored to serve a compelling governmental interest. Plaintiffs do not identify any governmental interest at all. All right, they're just citing more cases here. All right. Administrative burden. Finally, plaintiffs' request would impose an impossible administrative burden. They ask this court to police every video, every social media post, every caption, and every hashtag. That is not a judicial function. It is censorship. This court cannot and should not become plaintiff's speech monitor. The First Amendment forbids it, and Minnesota precedent rejects it. Conclusion on Dahlberg. Plaintiffs have not carried their burden under Dahlberg. They have not even tried. Their motion contains no meaningful discussion of the governing factors. No attempt to reconcile their requests. Yeah, okay. The law's clear injunctions are extraordinary remedies, never granted as a matter of right. When the First Amendment is implicated, the standard is even higher. Prior restraints are, quote, the most serious and the least tolerable infringement of constitutional rights. Right. Okay. Okay. Every factor forecloses relief. They cannot show a likelihood of success because they confuse common law malice with actual malice. They cannot show irreparable harm because reputational injury is compensable with damages. They cannot tip the balance of harms because no amount of discomfort to them can outweigh the unconstitutional silencing of a journalist. They cannot invoke public policy because the policy of this state and this nation is to protect, not censor speech on matters of public concern. And they cannot propose an administrable injunction because what they ask this court to do, review and police every utterance defendants make, is impossible. At bottom, plaintiffs do not seek an injunction because they expect to obtain one. Okay. Finally, defendants note that any injunction against speech would constitute a prior restraint of the most serious kind. Should this court grant plaintiff's motion, defendants will seek an immediate review, including relief by writ of prohibition if necessary. Okay. Plaintiff's strategic motives confirm the motion is improper. First, plaintiffs seek to smuggle new evidence of malice into the record. This is the centerpiece of their motion, and it is improper. Plaintiffs know they are barred by Minnesota General R. Practice 11511 from introducing new factual material in connection with summary judgment reconsideration. The only way around that bar is to disguise the same evidence as part of a different motion. The injunction request is that disguise. But the malice plaintiffs invoke is not the malice recognized in New York State versus Sullivan. Actual malice means publishing with knowledge of falsity or reckless disregard of the truth. It does not mean ill will, hostility, or bias. Minnesota courts have made the distinction explicit. Common law malice is not the test. Okay. First, it seeks to import material into the record that plaintiffs could not otherwise offer under the rules. I know, Kitty, I hear you. All right. I want to get to the end. I want to see how they wrap this up. Then I got to let my cat out, and then I have to curl up with my other cat. All right. So the scope and timing of plaintiff's destruction. On August 15, 2025, years into this litigation and after receiving multiple targeted discovery requests, plaintiffs engaged in wholesale destruction of their social media presence. This was not selective document destruction. It was complete obliteration of the primary evidentiary source underlying this defamation case. But it wasn't their posts that were being called into question. It was Katie, so I don't know what that means. Sorry. Okay. Plaintiffs admit they deleted their TikTok and Instagram accounts in their entirety on August 15th. Their defective affidavits state, quote, I deleted my social media presence as a result of the backlash from defendants' increased aggression this year. The deletions were immediately noticed and reported across multiple media outlets. People Magazine, Daily Mail, okay. More than 3 years ago, defendants served discovery requests requiring plaintiffs to preserve and produce precisely this material. Okay, good for you. On July 26, defendants sent a letter to plaintiffs noting the discovery of potential social media content that might be relevant to the lawsuit and asking for supplementation of discovery, including a full archive of Ms. Derrick's social media account information. Plaintiffs did not respond to the correspondence from Moore to Stavig dated July 26, and discovery closed shortly thereafter with no opportunity for additional motion practice. These requests were appropriately tailored and encompassed exactly the type of material plaintiffs now claim justifies their defamation lawsuit. Plaintiffs were on clear notice that their social media content was central to both their claims and defendants' defenses. The destruction was total, not selective. Okay. Metadata, engagement data. All right, Jinx, just a minute. Oh my God, the cat doesn't stop meowing. All right, I'm going to wrap this up here now. Let me take care of the cats and then go to bed. But I will be streaming again tomorrow because I have some free time tomorrow. So yay. I don't know what time though. It's probably not going to be until I want to do it though during the day, especially if it's nice outside. I want to go sit outside and do it. So it'll be like before dinner time probably. But let me go over here to chat. Hi, Gracella. Yay. Hi, Mimi. Hi, Jill B. Hey, Crystal. Hey, Sad. All right. Shh, cat. Shut up. Shut up, cat. I'm sorry. I'm being an asshole with my cat. He just likes to go outside and kill things. He brings me little presents. I get to take the dog out in the morning and see what my cat brought me this morning. That's crazy. All right. I'm going to go let him out. Thanks for being here, and I will see you guys tomorrow. There's a few other things I kind of wanted to talk about tomorrow too, so it should be more of an exciting stream rather than just a quick reading or run through skimming of a court filing in the middle of the night. So yeah, thanks for being here though, guys. I'll talk to you later. Bye. Shh, stop meowing. Bye.